Hello, everyone.
Hello.
Welcome to the Employment Rights Bill. Where are we now?
Leeds.
Yep, we are in Leeds. That's right. And this is Simon Robinson. That's me.
David Silito.
That's him.
I'm him or me.
And we're only
depending on your perspective.
Yeah, we're only going to be doing this for like 20 or 30 minutes, aren't we?
We are.
And then we'll just go and do our own thing.
Yeah. We don't send the slides around, by the way, before anybody asks.
Yeah. So there you go. So I hope you're all doing well. It's nearly Friday. And the big news yesterday, what there, the House of Lords went through the rights bill.
Oh, I was up all night.
I barely slept.
It was in Parliament TV.
Yeah, it was like when the Oscars are on.
Yeah.
Yeah.
I don't watch that either.
Oh. so the do you want to talk about that, the agenda, Dave, or am I talking about that?
Talk about the agenda.
The agenda, well, that's it. The Employment Rights Bill, the current status or status, if you're American. The Employment Rights Bill, the roadmap, same in American.
Yeah.
Government v House of Lords.
I think, I don't know if that is some sort of battle to the death, sort of government versus the House of Lords, whether there's been some sort of AI simulation done.
Yeah.
If there was, I do wonder who would win. Government obviously has fewer people, but House of Lords tends to be older, so it could be quite finely balanced. There you go.
That's a joke.
Yeah.
So you're going to all enjoy that.
Yeah.
My joke on that was Government v Lords. It's like the less successful sequel to Kong v Godzilla. So there you go. That's the joke.
I think that's the last from
So what is next, and what should the employers doing now? That's the height of the agenda, isn't it?
It is.
So May 1st, the Employment Rights Bill, there we go. That's the current status, or let's say an American status. We're all inclusive here. So as many of you will be aware, probably all of you will be aware, otherwise it'd be weird that you're on this call. The Employment Rights Bill was introduced in the House of Commons 10th of October 2024. Glorious day. The bill has now had the third reading yesterday in the House of Lords. The bill was passed and returned to the Commons with some amendments. We'll go through those, won't we, David? As the government and the Lords have yet to resolve the differences, the bill is expected to enter a stage of parliamentary ping pong.
I like ping pong.
Yep. Following the third reading stage, this process involves the bill moving back and forth between the governments and the Lords until both sides agree on its wording. Democracy in action.
Yeah. Defeated the point of euphemism by then, talking about that back and forth. Really?
Yes.
Yeah.
So with Parliament set to recess on Friday the 19th of September, the government only has a limited window to secure its passage before the Labour Party conference in Liverpool takes place. So that's from the 20th of September to the 1st of October. So with all these limited windows, it's very much a dull version of the Premier League's transfer window. And the bill is expected to be given royal assent in autumn 2025 to become the Employment Rights Act 2025. However, this does not mean all changes will come into force then. Oh, no.
No, it doesn't. So I meant obviously metaphor, not euphemism, by the way. I feel very silly. On the 1st of July 2025, the UK government released its official roadmap for implementing the bill, putting an end to uncertainty around its timeline. That sets out a phased approach, beginning with measures that will come into force upon royal assent, followed by further reforms rolling out through 2026 and into 2027. And we'll come on in a bit more detail to discuss what those will be. There'll be planned consultations. We're going to talk about those, and guidance periods to ensure readiness across businesses, trade unions and other stakeholders. And the government says they're going to collaborate closely with ACAS, who will play a key role in implementing the new measures and continue to support both employers and workers going forward. That'll be a different arm, hopefully, of ACAS to deal with ACAS early conciliation, where they're currently chronically underfunded. Hopefully that will all work out. Now we're going to move on to the next stages in the roadmap.
Ooh. So once the bill receives royal assent, the following provisions will take immediate effect: repeal of the strikes, brackets, minimum service levels, close brackets, Act 2023, repeal of key elements of the Trade Union Act 2016, subject to further consultation, removing the 10-year ballot requirement for trade union political funds, simplification of industrial action and ballot notices, and protections from against dismissal for taking industrial action. Employers will be prohibited from dismissing staff for participation in lawful industrial action.
Okay, so now we come on to a little bit more of the detail. So from April 2026, there are several key reforms that are expected to take effect. Firstly, we cover April and then October. That would seem to be logical.
Yeah.
So from April, we've got
Chronological.
We've got new day one rights. So this is employees gaining immediate entitlement to unpaid parental leave and statutory paternity leave, the removal of qualifying periods for paternity and unpaid parental leave will extend eligibility, obviously, to a broader group of employees. But as paternity leave is limited to 2 weeks currently, they are consulting on family leave elsewhere, but currently it's limited to 2 weeks. Parental leave remains unpaid, so that limits uptake for obvious reasons. So the impact is likely to be minimal in terms of those amendments. Secondly, strengthening whistleblower protections. So this is enhanced legal safeguards to provide broader protection. And the most significant of these is that workplace sexual harassment complaints will be recognised as protected disclosures under whistleblowing legislation. So what that means is that if workers are dismissed or suffer any detriment because of their harassment complaints, they can bring a whistleblowing claim in relation to a victimisation claim. And if if the detriment that's alleged is dismissal, that'll be an automatic unfair dismissal claim. And they'll be entitled to, if their claim succeeds, reinstatement. And importantly, if they comply with the strict time limit requirements, they can make an application for interim relief, which is where the employer can order reinstatement of the employment contract pending determination of the claim at a final hearing. And that's a massive implications for an employer faced with that sort of application if there's a risk that they might lose that. Really importantly, I think this is probably the real purpose behind this amendment, is that any protected disclosure is excluded from the confidentiality provisions in a settlement agreement. So any settlement agreement starting point will be that a sexual harassment complaint could still be made and asserted, albeit not by way of a claim. So that will have been settled in the settlement agreement. Other matters: reform to statutory sick pay. So this is removal of the lower earnings limit and the 3-day waiting period. That'll improve access for lower paid and gig economy workers. Employers should review their sick pay policies and the contractual terms relating to statutory sick pay to ensure compliance and fitness for purpose. There's also going to be the creation of a Fair Work Agency. So this is going to be a new regulator, as far as we're aware, to sit alongside the Employment Tribunal. They're going to be established to oversee compliance with fair work standards, arbitrate disputes, and enforce core provisions of the bill. We need to see the detail of that. The establishment of the agency is expected to make it easier for workers to enforce their rights, which is likely, of course, to be welcomed by workers and trade unions. It'd be odd if they didn't. Final two from April 2026, changes to collective redundancy rules. So we've all been familiar with these for decades now. The threshold remains at 20 or more proposed redundancies within a 90-day period for collective consultation. But there's going to be a new additional threshold introduced based on the total number of redundancies across the employing entity as a whole. So at the moment, there's a distinction whereby it has to be one establishment, but if across the employer as a whole, there's going to be 20 or more, then there's going to be an obligation now to collectively consult. So that will, of course, mean more occasions where collective consultation is necessary. The exact threshold is yet to be confirmed, but it might be defined as either a percentage of the workforce or a specific number of redundancies. The maximum protective award, so separate point, the maximum protective award for failure to consult is going to increase from 90 days pay to 180 days. So that's a huge amount. The duty to consult, of course, will apply more frequently. And the increase in the maximum penalty for failing to comply will mean the consequences of not complying are even more severe. And finally, for April, simplified trade union recognition and digital balloting. So recognition processes are going to be streamlined with new provisions for electronic and workplace-based ballots. Strike ballots and notice requirements will be relaxed, and electronic balloting will be introduced. Additionally, the process for trade union recognition will be simplified. The government's proposals are likely to significantly increase the role of trade unions in employee relations, as you'd expect. It'll make it easier for trade unions to organise strikes and other forms of industrial action, and it'll be more challenging for employers to manage those disruptions. Okay, so moving on to October 2026. A number of additional changes are expected at the moment to take effect then. Firstly, a new proactive duty on employers to take all reasonable steps to prevent sexual harassment in the workplace. Now, our view, we only have one opinion we share at all times, is that there's no real difference between the current duty to take reasonable steps and the new duty to take all reasonable steps. Whilst on the face of it, yes, it does seem like it's more onerous. If there are reasonable steps that you're not taking now, and you say that you've taken reasonable steps, well, you're unlikely to be able to demonstrate compliance. We have very little guidance on that in terms of case law, though. But yeah, all reasonable steps. I mean, that's certainly a high standard. And if there is a reasonable step that can be pointed to that hasn't been taken, then that's definitely not going to be compliance with the duty to take all reasonable steps. If you're already compliant with the duty or believe you are, if you've already taken steps towards that, you're likely to be in a very good position. And we always say you should be continually reviewing it anyway. It's not a static duty. It will change as the business changes. So the businesses should hopefully be addressing their minds to that anyway. New third-party harassment provisions in relation to third parties will actually apply to all forms of harassment, requiring employers to implement appropriate safeguards. This will include ensuring contracts with clients, suppliers, and other third parties contain clear language addressing expected standards of behaviour and responsibilities. And of course, it's much more difficult for an employer to manage those third-party relationships. So this is just showing that you can go some way to doing that. Next, a ban on fire and rehire practices, preventing employers from using dismissal and re-engagement as a tactic is what they have said. The plan at the moment is that it's going to be automatically unfair to dismiss an employee for refusing contract changes related to pay, pensions, hours, holidays, or other regulated terms. The same will apply to dismissals aimed at re-engaging the employee or replacing them with another worker on new terms, even if those terms are not related to pensions, hours, holidays, pay, etc. A limited exception is due to apply where changes are essential to keep the business viable and could not reasonably be updated. Now, this is something that has been amended in the House of Lords yesterday, or proposed to be amended in the House of Lords yesterday. So where the changes relate to something other than pay, pension, hours, holidays, or the other specified terms, the House of Lords has proposed that any dismissal for refusing to agree to the changes could still be fair, as long as the employer has followed a 6-point checklist, which will include things like extensive consultation and, where appropriate, inducement. So that may well be accepted by the government. Moving on, time limits are going to be increased. So it's a massive change culturally and risk-wise for employment tribunals, moving from a 3-month time limit to 6 months. And at the moment, I mentioned ACAS early conciliation. I'm told there's a 5-month lag between starting ACAS early conciliation and the employer being notified that the employee has done so. It could be 8 months after termination before you can really know that you're in the clear from a claim, once we move to 6 weeks, unless they bring that time frame down by more investment in ACAS. And of course, we'll need to see more funding for the employment tribunal system. Very briefly, the final few on the list: new rules on tipping and gratuities, requiring employers to pass all tips directly to staff and ensure fair distribution. Establishment of a fair pay agreement negotiating body, beginning with the adult social care sector, and then broader trade union rights, including greater access for representatives and extended protections for union activities.
Excellent work. So roadmap continues. So from 2027 onwards, we've got the big one, I think, the day one unfair dismissal rights, and the government's plan is that all employees gain the right to claim unfair dismissal regardless of length of service, which replaces the 2-year qualifying periods. We're talking about big shifts. That's the big shift, because it's going to give so much more, so many more employees the chance to bring the claim. Obviously, as Dave says, if we don't have funding for the employment tribunal, effectively we're just going to get longer and longer delays within the tribunal. And eventually cases that are being taken, a year or 2 years to be heard now, could take maybe 3-4 years, who knows? So the funding really is essential if the government wants this to work. It's going to be essential to include a new probationary period in all employment contracts, because currently probationary periods are only a contractual construct. They've got no legal meaning other than the typically a shorter notice period if you're dismissed within it. So you're going to need a new probationary period in all employment contracts, and to establish a clear process for regularly reviewing employee performance during the time. Employers should reassess their disciplinary and dismissal procedures and ensure that managers are properly trained to handle conduct and performance issues effectively. We're going to come on in a bit and talk about what the House of Lords said about day one in our Government v Lords section, which I know you're all looking forward to. Expanded protections for pregnant employees will be introduced alongside new statutory bereavement entitlements, and those changes will strengthen safeguards against dismissal during pregnancy, whilst on maternity, adoption, or shared parental leave, and for a period of 6 months following return to work. So employers must ensure they have robust processes and adequate training in place to avoid the unlawful dismissal of employees who are on or have recently returned from family leave. Whilst many employers already provide some form of family bereavement leave and increasingly have policies addressing pregnancy loss, those without such policies should really take proactive steps to introduce them in preparation for the upcoming statutory leave entitlements. Umbrella company regulations. I don't know whether I was going after umbrella companies, don't you?
I know, it hasn't even rained this summer, hasn't it?
So agencies and umbrella companies will be brought under new licensing and transparency requirements. There are 0-hour contract protections. Employers will face tighter restrictions on 0-hour arrangements that the government want to do, including mandatory compensation for cancelled shifts and a new right to request predictable working hours. So if you're an employer that relies heavily on casual or 0-hour workers, you should review current arrangements to identify individuals who may now qualify for regular hours contracts. Additionally, if shifts are frequently offered at short notice or regularly cancelled or shortened, it would be prudent to evaluate and improve these practices to minimise the risk of claims once the new regs take effect. 2 more. Mandatory gender pay gap and menopause action plans. So whilst employers will be encouraged to publish action plans from April 26 on a voluntary basis, the requirement will become compulsory from 2027. And then the finer details are obviously going to be crucial, as the government intends to outline the specific content, format, and publication requirements for those action plans through forthcoming regulations. So employers may wish to consider what narrative they already publish or could publish alongside their gender pay gap figures, and how this could form the basis of a gender pay gap action plan. Employers who do not have a menopause policy should consider introducing one. And then finally, ban on non-disclosure agreements, NDAs, confidentiality clauses used to silence victims or witnesses of workplace harassment or discrimination will be rendered void. This reform is intended to increase transparency and empower workers to report misconduct without fear of legal repercussions.
There we go. So just because of the umbrella joke, thought people might appreciate an extra bit of trumpet. The consultations. So those are going to start, and it's said from summer/autumn 2025. I'm pretty sure we're looking out the window into the autumn already. You can see them here on the screen, but we should shortly see consultation launched in relation to protection from unfair dismissal from day one. I would imagine there'll be lots and lots of opinions on that. Trade union measures as well, possibly, definitely of narrower application, but likely to be something that people feel quite strongly about. Fire and rehire, bereavement leave, rights for pregnant workers, and ending the exploitative use of 0 hours contracts. And I will just reiterate that the whole parental leave, paternity leave, and so on system is currently under review as well. Consultations in winter 2025/early 2026 will cover trade union measures, tightening the tipping laws, the collective redundancy procedures, and the flexible working arrangements, which we've talked about elsewhere on other webinars. But yeah, I mean, probably all those likely to be of slightly less import than the first of these two on this screen, which is the protection from unfair dismissal and trade union measures. But the main message is, if you love consultations, then keep your eyes peeled.
Thank you. So Government v Lords, finally it's here, the battle of the ages. So you can see in that's a table that we've done there to make it quite clear. So the government's position on 0 hours contracts is that workers should still be able to choose them, but with strong protections, including a right to a contract reflecting average hours regularly worked, reasonable notice of shift changes, compensation for shifts that are cancelled or cut short. And the government's proposal requires employers to offer minimum hours automatically once an employee's average hours exceed their contracted hours, even if the worker does not request it. The Lords propose to limit the obligation so that the right to uplift of guaranteed hours only applies when an employee requests it, and that approach would reduce the administrative burden on employers who would otherwise need to continuously monitor hours worked and adjust contracts accordingly. Seems quite sensible, so let's see how that plays out. Unfair dismissal rights. We wanted to make a day one right subject to a lighter touch process for dismissal during a statutory probationary period. And the length of this probation period is under consultation with the government, indicating a preference for 9 months. The Lords, however, take the view that the right to claim unfair dismissal should only apply after 6 months service. For anyone who's interested in my opinion, I think it should be a year. But if I had to pick one, it would be the House of Lords for the funding issues.
Just to clarify, though, no one is interested in your opinion.
Oh. So, ban on dismissal and re-engagement. The government want to ban all fire and rehire dismissals, but you see what the House of Lords there say, where the pros contract. Well, I think you covered this already.
So, what is next? The bill is expected to receive royal assent in autumn 2025. Again, pretty soon. That's going to become the Employment Rights Act 2025, just 29 years after the original. 29 years later, that'll be the film they make about it, won't it? Whilst the bill establishes the broad legislative framework, many of the key reforms, as usual, are going to be set out through secondary regulations and statutory codes of practice. No obligation to consult in terms of secondary regulations. So the importance of consulting in relation to the primary legislation is really high. To help employers prepare, it's very nice of them. The government has published a phased implementation roadmap, providing early notice of when specific changes are expected. But that timeline could shift as the bill experiences delays as it progresses through Parliament.
So I think if I were to see 29 years later, Dave, and if it didn't have zombies in it, I'd be very disappointed.
Yeah.
But I should say, no one cares what I think.
No.
So what should employers be doing now? Well, although the reforms, some of them are a way off, it's a valuable opportunity for employers to instruct Robinson Ralph by getting us in for training for your management HR team, reviewing your existing policies and contracts, to get signed up to our insurance scheme, that we can protect and tribunal. In fact, just in the last couple of weeks alone, myself, Dave and Nick have all had great results in tribunals, and we can deliver that service for you as well.
Absolutely. So we've got our Employer Protect retainer, which is, as you'd expect from a retainer, provides cost certainty and the ability to just phone us up, and generally have a specific point of, or you'd always have a specific point of contact. You always have all of our details.
It's the retainer that provides protection to employers, isn't it?
But it's a very personable and personal service.
Yes.
And we might even throw in some of the jokes, but we probably won't use the trumpet on advice calls. But So I say this, obviously it's a sales pitch, but genuinely, compliance with employment law is only going to become more important, not only because things are changing, and therefore it becomes harder to know what to do. You can't necessarily know what to do just because what you've done in the past worked out okay, but also with the increased number of people who are going to be able to bring claims, because there's going to be longer time limits to bring claims, because there's going to be more people who can claim unfair dismissal, because there's going to be more complexity around how do you get out of the sexual harassment allegation and settle that. the retainer and the insurance product, as Simon mentions, is certainly things you should probably consider. So if you want to do that, then there's photos of us. We all look that good all the time, don't we?
Yeah. I
Um,
don't think Nick has ever taken a bad photograph.
no. So yeah, there's the information and info@robinsonralph.com. If you want to have a look about more, see a bit more about the firm, robinsonralph.com. And then there's all the phone numbers there.
Yeah, they're just numbers in a specific order that if you ring them,
Yes.
you get to speak to each of us.
And that's how it works.
That's just phones. Okay, thank you all for listening. I don't know if you could see us during that. I don't think you could. I hope not, because I was swigging coffee as we were doing it. But
I think you could. I think they could see us.
could they? Oh,
Yeah.
oh
Yeah.
dear.
That's
Okay.
fine.
Anyway, thanks everyone. Bye.
Bye.